All right, welcome in everybody. This is a webinar on Estate Planning 101. We're going to be doing a webinar at least each quarter this year on different estate planning aspects and things that we want the community to be aware of and start working towards those goals of getting your future and making sure your future is secure for yourself and your family. My name is William King. I am the associate attorney that heads up the estate planning and probate branch here at the Meneely Firm PC. Thank you everybody for joining me this evening. We are doing these short webinars. I know everybody is busy, so our goal is just a quick overview of what estate planning looks like, what are the main aspects of it, and then we invite each and every one of you to set a consult with us and come talk to me individually, obviously when you are free or when you have the time to, and we can get more in depth into what your estate plan should look like based on your individual lives, and we can go ahead and start working to set that up. So again, thank you for joining us. I appreciate you all being here. Setting up your estate plan is extremely important. So I'm really glad that you all are here. So the first thing that I'm going to talk about, or the three things that I'm going to talk about, are the general documents that you typically hear about in estate planning. Those are advanced healthcare directives, power of attorneys, and wills. There's other documents, and we'll talk about those in the future, or specifically if you set up a consultation. But these are the big three documents that you're going to hear about. So I'm going to talk about those individually, and then we'll field some questions at the end. So the first one is an advanced healthcare directive. This one is also known as a power of attorney, a durable power of attorney. And so there's some confusion there as to the nomenclature or the name of the document, but it's an advanced healthcare directive. That's what it's generally called now. And an advanced healthcare directive allows you to select who you want to make decisions on your behalf should you become incapacitated. And so when you're looking at that, you want to make sure that you're thinking through, who do I trust to make these decisions regarding my health, regarding treatment that I would receive if I'm unable to relay those decisions on my own. In the document, you have the opportunity to select that healthcare agent. You also have the opportunity to select backup healthcare agents. So if somebody's unwilling or unable to, then you have somebody else who's there who could make those decisions on your behalf. And that's extremely important to have in place, especially somebody that you trust to make those decisions. In terms of making those decisions, there are general selections within the documents. And what I mean by that is you can say, I want everything, I want nothing, or I want these few things. And those are your generic selections. You're going to get to a section where you see A, B, and C. I want A, nothing, B, all, C, these several things. However, there is a section that comes after that that allows you to get very specific on what you want in terms of the treatments that you would prefer in specific situations. Blood transfusions. I don't want to get too graphic, so I won't go into a lot of it, but things like that, thinking through if you're in a specific scenario or what you might want in a specific situation. And then again, you do have those generic selections as well. The other aspect of an advanced healthcare directive, and I think it's really important to point out, is within that advanced healthcare directive, you can select who you want to be your guardian if somebody were to file in probate court to be a guardian over you. And what that means is you can have in this document who you want to make decisions for you in regards to your health should you become incapacitated. If these documents are not in place, and even if they are in place, somebody could go to probate court and file for guardianship over you if you're incapacitated or unable to make decisions for yourself. Now, typically, if you have this document or not, or you don't have this document, either way, you can see instances where people will go and file and they'll be fighting over who is supposed to make decisions on your behalf, as opposed to everybody understanding who you've already decided you want to make those decisions. So again, that's why it's important in this document, you select your healthcare agent, but you also select who you want to be the guardian. And typically that's the same person that you select as your healthcare agent. And why it's important that you select it in this document is if you look at the statutes regarding guardianship, there is a statute that lists out the preferred order of who would be selected as your guardian, from spouse to children to, on down the line, parents, etc. The first one is somebody that you have specifically selected as your guardian. And that's what you do inside this document. And so that limits any confusion down the road of, well, if something happens to them, is there any question of who's going to make decisions? And then it also limits exposure in terms of litigation, of being in court. It limits that in the sense that if multiple people go and file, the person who's supposed to be making those decisions on your behalf has already been selected by you, and they present this to the court, and it's a clear-cut answer for the court. The court says, okay, this person selected Tom or Mary or whoever that may be to be their guardian. I'm going to enter an order that says this person is their guardian. So not only are you secure in the sense that immediately you're going to have somebody that's making decisions on your behalf, but if something's ever filed to be guardian over you, that's also taken care of. So you protect yourself, you protect your family, you limit, hopefully you limit the arguing or possible litigation that goes on. But again, extremely important to have this document in place. Power of attorney. This is similar to an advanced healthcare directive. A power of attorney allows you to select an agent to make decisions in regards to your finances and property. The difference here is immediately, without any specific instructions, the power of attorney goes into place immediately, whereas the advanced healthcare directive only kicks in if you're unable or you're incapacitated and unable to make those decisions on your own. So again, there's a little bit of a difference in the documents in the sense that the power of attorney goes into effect immediately, unless you set out in the specific instructions section that you want there to be a delayed effect. And what that means is you can set out that it doesn't take place until you become incapacitated. And that's certainly something that we've done before and that I've seen a lot of people do. So you do have that option, but it's not standard. So when you're thinking through these things, that's something else to think about. Again, this document, just like the Advanced Healthcare Directive, you have some generic options of what you want a person to be able to do on your behalf. Go to the bank, pay bills, access, certain financial accounts, things like that. And then you can get very, very specific in terms of something that you want somebody to be able to do on your behalf. A lot of times I see spouses enter into a power of attorney for their spouse, their significant other, or partner, whoever that may be, in order to, especially if you travel a lot for work, that's probably the most important time to have a power of attorney in place. If you're out of town a lot, things like that. Again, it's also important to have this in place because just like the Advanced Healthcare Directive, in terms of selecting a guardian, in the power of attorney, you can select a conservator. So similar to a guardian, a conservator can be ordered by the court. And if you are ordered to be the conservator by the court, you're going to make decisions in regards to a person's finances and property. So again, if you select that conservator, you're going to be limiting any future litigation, hopefully, by selecting that conservator who's going to make decisions if you do, in fact, later become incapacitated. So you do have that option in both the Advanced Healthcare Directive to select a guardian and the power of attorney to select a conservator. Both important things to do. And I'll just say this, there are a lot of details in these documents that I could spend hours going over. And that's certainly what I would love to do with each and every one of you is we can sit down and do a consultation and I can go through these specifics with you in more detail. Tonight, I just wanted to give you an overview of kind of what these are, but I would love to sit down with each of you and go over the specifics of these so we can get these in place for you. The last document and the biggest thing that most people hear about is a will. I got to get a last will and testament. I need to get that in place. What does that entail? What can I put in there? Anything you could think of, you can put inside a will. When I was in school, we covered all sorts of wills, examples, cases where wills were disputed, things like that. But one of the fun things that we did when we were in our wills, trust, and estates class was we covered some very interesting wills, and some of them had provisions that were like, I want to pay John $100 on the third Tuesday of every month for 3 years. and that's all he's going to get. But he's going to get that $100. And there was a specific reason why. I can't remember off the top of my head, but I give you that example to say you can be as specific as you want in a will. You can be as general as you want in a will. Everything to my wife, everything to my kids and even shares, everything to Tom, $100 on the third Thursday of every month. Again, general to specific. However you want to set that up, you can set it up to make sure that the property that you have is going to go to the people that you love and care about and that you want to have. You can have specific bequests in there. I want to give my car to this person. I want to give my old blanket, the old family heirloom blanket to this person. I want to give this piece of jewelry to this person. Again, you can go through and be as specific as you want or as general as you want. Other things that you can set up inside the will, you can set trusts up inside a will. Those are referred to as testamentary trusts. Those will help most of the people that I see that set those up, if they have young children, or sometimes grandparents will set up testamentary trusts for their grandchildren if they want to leave some money to the grandchildren. And you can, again, leave instructions inside those, which talks about here's how I want money distributed until this age, 18, 21, 25. I've seen up to 35. So it really is up to you on how you want to structure these things and how specific you want to get based on your life, based off the loved ones that you have in your life, based on what you feel comfortable with. So, think through those things, think through what's important to you on how you want to leave your property inside a will. The other things that you can do inside a will is if you have children, you can set up what's called a testamentary guardian and or conservator, very similar to if you as an adult are selecting a guardian and conservator in your advanced healthcare directive or power of attorney. But if you have children, then it's obviously, it's a guardianship conservatorship for a minor child, but you are letting the court know who you want to be take care of, who you want to take care of your children. If something were to happen to you and your spouse, that is something that I talk to parents all the time about. You're going to want to think through, I need something set up in my will that says, okay, if something were to happen to me or my spouse, then I select X as a guardian. I select, Y as a conservator. I select them as a guardian and conservator. You can have backups for that as well. So it's very important to think through that and think through, again, who do you trust in the situation to be able to handle those things for you? Who would be there to take care of your children? So another thing that you can put inside your will. Again, I think that's kind of the 30,000 foot view of these documents. They're very, very important for you to have in place. I have seen in my experience in probate litigation, a lot of difficulties come up when people don't have wills in place, don't have estate planning documents in place. It's so important to have these things in place because you protect yourself, you protect your family, you make sure everybody's in a good spot. You limit confusion down the road. Hopefully you limit infighting. I've seen my fair share, and I don't mean to laugh. I laugh because sometimes it can get, just out of control in the sense that, doing these things up front is so much easier than having to deal with it on the back end. So, I'm very passionate about this stuff. I think it's very important that you have it in place. I would love to talk to each of you individually. So please call us to set up a consult. We are doing a promotion. If you call us by tomorrow at 5:30, again, that's March 25th by 5:30 close of business, we will waive the typical consultation fee that we do. You don't have to have the consult tomorrow, but just give us a call and set up that consultation and we'll waive that consultation fee. We'll get you in, we'll talk about your estate plan. Hopefully, you give us a call, we'll get all of this set up. I'll talk to you in more detail. There's some other documents that you can put in place if they make sense for you. So give us a call. Let's talk about that. Let's get your estate plan set up. This stuff is just so important. So thank you for joining us this evening. I really appreciate your time. We try to keep it short, 15 minutes. I know everybody is busy. I will open it up for questions. Please feel free to ask any questions that you have. And then once we get done, we'll wrap up and I hope everybody has a wonderful evening. So again, thank you for joining us. And if you have any questions, let me know.
Thank you very much. We'll be in touch.
Hey, yes, sir. Yeah, you're absolutely, you're welcome. Happy to help. What's your question, sir?
We'll contact you by tomorrow and set up a consultation.
Perfect. Please do. I would love to talk to you. Love to answer any questions that you have. Just contact our office at 770-421-0808. You should have gotten that information when you registered, but just in case you didn't, give us a call there. Just speak with the client care coordinator and they'll get you set up. Let them know about the promotion, that we are waiving that consultation fee if you call by 5:30 tomorrow, and they'll get you set up with us. Okay, sir?
Thank you very much.
Thank you, sir. I look forward to speaking with you.
Okay, bye.
I got a chat question here. Do I need a lot of assets to need this? No, you don't. Certainly not for the Advanced Healthcare Directive and Power of Attorney, and in my opinion, not for a will either. A lot of people think, you need assets galore. You need investment accounts. You need properties. You need any kind of assets you could think of. No, that's not necessarily true, because there are a lot of ways in which you can set up a will to protect your family against certain things like creditors. And that's something that we can get in depth with your consultation. Is you can set up wills, but especially trusts. So you can set up trusts to protect against creditors. You can set up wills in which testamentary trusts are created, which will protect against creditors. So it's very important to have something like this set up, even if you don't have a lot of assets. One, just a few assets that you want to pass on to family. That's extremely important. Two, you never know if you're going to come into a windfall of assets. You could inherit more than you could imagine tomorrow. And then something happens and you don't have a will set up. So you can set up a will in which it does contemplate getting more assets down the road, and certainly something that we can talk about in terms of setting it up that way. And we can also talk about what's the easiest way to update your will if you do have certain life events that change, something like a marriage, a divorce, having children, getting a lot more assets, purchasing a home, things like that. We can update the will. But even if you don't have those things, it's important to get a will in place. Outside of the assets, though, the Advanced Healthcare Directive and Power of Attorney, those are extremely important to have in place if you have no assets, because then you have somebody that's able to make sure, or very little assets, because then you have somebody that's in place to be able to make decisions regarding your health and then your property and your finances. So if you need somebody immediately to help out with, the assets that you do have, they'll be able to do that. That way, if you have a house and you can have them help out with paying the mortgage so it doesn't go in foreclosure, things like that. So even with limited assets, this is very important to have in place. So great question. Any other questions out there? All right, looks like we don't have any other questions. Thank you so much for joining me this evening. Again, having an estate plan in place is extremely beneficial. It is so important that you do this. Please give us a call. Again, we're waiving that consultation fee tomorrow. If you call by, again, that's March 25th, close of business 5:30, we'll waive that consultation fee. Give us a call. Let me help you set up your estate plan. It's very, very important. Thank you for joining me this evening, and I hope you will join us in our next webinar, and we'll send out invites and promote that so that you have the opportunity to take part in that webinar as well. So thank you very much.